Hi everyone, it's Michael Wong here. I'm an Australian lawyer and a registered migration agent. In this video, I'm going to cover what will happen to partner visa next year. In particular, I'm going to talk about the sponsorship application before the visa application. Before I go into the details about this amendment, I would like to talk a little bit about the history of this amendment. Back in 2016, the Parliament was introduced a bill called Migration Amendment (Family Violence and Other Measures) Bill 2016. This bill was argued or debated by both of the House of Representatives and the Senate for about 2 years, and until November 2018 the bill was passed and received the royal assent on 10th of December 2018. That means the bill became in effect. And the bill actually got four purposes. It aims to require the Australian partner be approved to be a sponsor before the foreign partners makes a partner visa application. The second purpose was to impose some obligations to the sponsor. And the third purpose was to impose sanctions to those partners or to those sponsors who can't actually fulfill the obligations. The last is to allow immigration to share some information to of the sponsor to the applicants. What it means is if the sponsor have some criminal record or adverse information, the Department of Immigration can actually share this information to the applicant. So if the applicant is okay with that, it's okay, it will pass. If not, it's not, okay? But to be honest, I haven't seen anyone who actually not consent the department to share the information. So the second, third, and fourth purpose have been fulfilled. But the first one, it requires the sponsor to be approved to be a sponsor first. Then the applicants can apply for the visa. For this part, it has not been imposed. So the treasurer or the government actually would like to implement this purpose by the end of next year. So before the end of next year, it will be implemented. So the question is how it will be implemented and what's the outcome of it. Because there is no legislation about this, I have in my mind there are two possibilities. First, it's like what we're doing now for employer sponsorship. So for employer sponsored visa, we have sponsorship, nomination, and visa. Other visa got like nomination and visa. In this employer sponsored visa, we can actually lodge 3 steps or 2 steps, everything together in one day. So sponsor, nomination, and visa application, lodge, bang, done. And then by the time when immigration try to grant the visa, it will be granted in order. So they will grant the sponsor first, they will grant the nomination first, and then the visa application. If the partner visa follow this operation, it's okay. It will not cause many issues. However, if the department actually is in line with what the treasurer or the government said, the sponsor has to be approved before the visa application is lodged. So you have to have a sponsor approval first. Then you can lodge the visa application. If that's the case, it's going to be problematic because what happened now is a lot of visa applicants, they came to Australia on other visa and then apply for partner visa. In this case, what we can see is we have no idea when or how long the sponsorship will be approved. In that case, we cannot guarantee the visa applicant can lodge the visa application before the visa expired. So they will have to spend extra money to apply for other visa so that they can stay in Australia lawfully and wait for the sponsorship to be approved. Second, it's the same thing. Some people, they leave it until the last minute, even they are on a visa in Australia for a long time, let's say a student visa. Okay, they're on student visa, they met a boyfriend, met a girlfriend, and then they get married or they live together, become a de facto partner. However, they haven't actually prepared for the visa application for long enough, and then they don't have much information. They can't actually apply for sponsorship, or the sponsorship application cannot be approved before the visa application, the visa applicant's visa expires. So that's another problem. I would say again, they have to do something. They have to lodge another visa to make themselves lawful in Australia. Okay, what happens if they don't actually make an application to make themselves lawful in Australia? They will become unlawful, and if they're unlawful and apply for the visa partner visa, what will happen is you have to demonstrate to the department that you have compelling reason, you have compelling circumstances for you to stay in Australia to apply for the visa, not going back, not leaving, not departing Australia to apply for the visa. Not all the cases will have compelling reasons, so your visa will be in risk. Another issue is some people might actually misunderstand the visa regime. So they may think, okay, once they apply for the sponsorship, okay, it will automatically grant them a bridging visa. It's very common, but that's not the case. So it will go back to another issue that you have to, by the time you find out you don't have any visa, you're not a lawful person in Australia, then you have to demonstrate you have compelling circumstances to apply for the partner visa in Australia, but not departing Australia. So that's the issue. So my recommendation is you have to, if you want to apply for the visa, seek advice from a professional and prepare the visa application as soon as possible, as long as you can. That's all for today. I hope you enjoyed this video. If you like this video, please like our video, comment our video, and share our video. If you like this channel and would like to receive any updated migration information or updated Australian law, please subscribe our channel and hit the bell so next time when we got new video, you'll be reminded we've got new video, we've got new news, we've got news for you to be updated. Thank you. See you next time.